Okay. Good morning, everybody. My name is Patrick Fife. I am LIBOR's General Counsel, and welcome to this morning's July legal update. I'm just going to get my slides started here in 1 second. Okay. So welcome to July's legal update. Again, my name is Patrick Fife. I'm LIBOR's General Counsel. If you could just do me a favor, and if you have any questions, please put them in the chat. I will be looking at it throughout, and I will do my best to answer them as we go. And if you have any additional questions, I can stick around for a couple minutes once the formal class is over. So before we get rolling into the content, I do just like to remind everybody that the best place for you to go in order to stay on top of all of the changes, the legal changes in your business is LIBOR's website and coming to LIBOR events. We really try to be your source for staying updated on industry changes. Um, I know a lot of you spend time on social media, other media outlets, and that's great. But I can tell you there's a lot of incorrect information out there, misinformation. And the place I'd like you to go to stay on top of things and continue to be updated is here to LIBOR. We're here for you. We're working for you. We're trying to help you in any way you can. Deal with changes as they happen. So what should you do? Please sign up for our emails if you don't get them already. Every Thursday, we send an email that has a ton of information, including weekly legal tips, information about upcoming webinars. If you are a broker and office manager, I highly encourage you, if you don't already get it, get the monthly broker newsletter. There's a resource deck, there's materials for your office meetings. We have a broker portal on our website that provides information specific to brokers, training materials, other types of information. It's really things to help you with risk management and staying more organized. And also make sure that you're signing up for our events. We offer a lot of great events throughout the year, and really dedicated not only to things like networking, but also education and training. I mentioned LIBOR's website, lirealtor.com. Um, Go there, make it part of your routine. I know you all go to Matrix and One Key, obviously, to do your business, list your properties, send out searches to your clients, that type of thing. But make it also part of your routine to just check out our website at least on a weekly basis. You may miss things in the email, and if you do, that's fine. It's all on our website. It's all there for you. Use it as a resource to search when you have questions about particular topics. More likely than not, we've got an article on that particular topic. And if not, you'll figure out and be directed to who to contact at LIBOR if you have a particular question. Um, a lot of information also on the legal section of the website. Not only are there access to the legal tips, but access to all of our documents on demand and forms. Our dispute resolution center, I always like to point this out to everyone. I'm hoping you're all familiar with, got it right here, your code of ethics and how to file an ethics complaint, how to file an arbitration if you're a broker and you have a compensation dispute, a contractual dispute with another broker. But we also have what's called an ombudsman service, and it's available through the Dispute Resolution Center, or you can contact a professional standards office. If you have any kind of communication breakdown with another realtor, right? And it could be in the midst of a transaction, and you're concerned that it's going to turn into a bigger issue. You've contacted your broker, you can't resolve it. And it may be something minor, but it could be something minor that may turn into a bigger dispute. That could be a problem for your client. It could be a problem for your office. This ombudsman service is a free service. Contact the professional standards department and they can put a experienced, trained, neutral realtor in touch with both parties to try to bridge the gap, resolve the differences, and reach an agreement and understanding on how to move forward without the matter turning into something like an ethics complaint like an arbitration. It's a free service. It's available to all members. And I highly encourage you to take advantage of it if you do run into some kind of issue. And call the professional standards department. Even if it's something we can't help with, they'll speak to you. And again, see if it is something that we can get an ombudsman involved in. And it's a highly successful program. I think on balance, over 80% of the cases that go to an ombudsman get resolved. And it's not a formal hearing. It's just through phone calls, back and forth. And again, it's worth a shot. It's free, and it can prevent a small issue from becoming a big one. Last benefit I just want to make you aware of because it relates to legal is our legal support center. It's something that we launched. It's in addition to, I know a lot of you are familiar with the NYSAR legal helpline. This is a LIBOR run benefit. It's our legal support center. It's staffed by an attorney, 9 to 5, Monday through Friday, who can provide you information on real estate related matters. It's a very helpful service. Not acting as your attorney, can't provide you legal guidance or advice on how to handle a particular situation, but can certainly provide you information concerning particular laws, particular issues, certainly point you in the right direction as to certain issues that may arise. Again, it's also a free service. The number's there. It's 631-661-4800. It's our LIBOR number, and it's extension 335 if you call that number. So a lot of you have called that number, right? And asked questions. So what I like to do every month is just go over some of the questions that were asked in the prior month, some of the repeating questions, just so you have a sense, because I figure if those questions are being asked by others in the field, you may have them too. So what has been asked this month or last month? This one came up a couple of times in the last few months. What do I need to do? Do I need to disclose when I have an interest in a transaction? Let's say I'm listing my own property. I'm representing myself in a purchase. What do I need to do? Do I need to disclose it? The answer is yes. If you're listing your own property for sale, you're involved in a transaction, you must disclose your interest to the other parties. It's required by New York State law and the Code of Ethics. So New York State law, right on its face, before a real estate broker sells a property in which he owns an interest, he shall make such interest known to the purchaser. We also have Article 4 under the Code of Ethics, which is even broader. And that says realtors who have a present ownership interest in a property for sale, lease, or a contemplated interest to purchase or lease have to disclose in writing the existence of that interest to all parties to the transaction prior to a party signing an agreement. So that not only applies to sales, but also purchases. And I will say at best practices, you want to make that disclosure as early as possible. It should be in writing. So, ideally before first substantive contact. I also think it's a good idea to redisclose it prior to the signing of a contract and even state it in the contract, just so there is never any question that disclosure was made. Also recommend if you're an agent, before you handle a transaction that involves yourself or even a family member, which we're going to get to in the next question, speak to your broker. Make sure that your broker is okay with that. I know some brokers may have issues, or not issues, but conditions or exclusions in their E&O insurance that may not provide them coverage unless certain things are done, certain disclosures are made. So just make sure before you handle that type of transaction, whether it's for yourself or a family member, you speak to your broker first. So next question, and this is, I touched on this a little bit, but what about when it's a family member? A lot of you may hold your license or initially gotten into the business because you were going to represent a family member. And that I know it happens frequently. Do you need to make any kind of particular disclosure there? The answer is yes. So we looked at Article 4 before, right? That talked about you need to make a disclosure in advance when you have a present ownership interest in the property. Standard of practice 4-1 defines present ownership to include more than just you. It says present ownership means when you represent yourself, when you represent a family member, a member of your immediate family, represent your firm or any broker or agent within your firm, or an entity in which you or your immediate family member have a legal interest. So again, Article 4, much broader than New York State law. New York State law just talked about a disclosure when you're selling your own property. The Code of Ethics is more comprehensive. It says this disclosure has to be made in any one of those circumstances. Question I know has come up, well, what's an immediate family member? How do I know? Well, the Code of Ethics and Arbitration Manual, it defines what an immediate family member is. And that would include you, your spouse, your siblings, your parents, your grandparents, your children, grandchildren, or other descendants. Best practices, if you're not sure if they're an immediate family member, make the disclosure in writing. It's just the smart way to do it, and be transparent. I always, my advice is whenever there's some kind of gray area, err on the side of caution. Disclose more. The more you disclose, the less likely there's going to be any issue. Again, with these kind of disclosures, I recommend that you make them in writing as soon as possible, prior to first substantive contact, and again, make a redisclosure within the contract, just so there's never any question that somebody says, "Well, I didn't know that the listing broker was, the brother of the seller." The more you can disclose, the better. Um, Another question that's come up a couple of times, and I'm glad Evan's on here because Evan's part of our staff liaison to our appraisal committee, which appraisal and valuation committee, which has done a lot in the last couple months to let our members know more about how to interact with appraisers. But a question that has come up is, do I have the right to interact with appraisers? Can I provide them information about a property? Does that create some kind of problem? Is there a legal impediment to that? Well, yes, you can certainly speak to appraisers. You can provide them with information about a property. You can't bribe, you can't intimidate an appraiser, and an appraiser, you can't ask that they disclose confidential information, but you can provide them information about comps, information about the property they're appraising. You can give them lists of improvement, property features. So I mentioned our appraisal and valuation committee. They just in the last 2 months or so released a new document. It's called an appraisal packet. It's available on our Documents on Demand. It's basically a fillable form that you can use to populate information about a property that is being appraised, and then provide it to the appraiser. And it should help the appraiser and ultimately, hopefully, help your client, be able to establish what the real true value of a property is. Last thing that comes up is sometimes you get the appraisal report back. You think there's errors in it. You feel the appraiser may not have considered certain information. What do? Well, you cannot, and you should not contact the appraiser. You need to contact the appraiser's client, and that would typically be the lender, in writing to explain what your concerns are. If you got more questions about this, we just did a legal tip on it a few weeks ago. It's all available on the website, as well as a link to the new appraisal packet. This question's come up a few times in the last couple of weeks. Can I co-list a property with another listing broker? And the answer is yes. And it may be a good thing to do. I know some of you have certainly been involved in cases. Let's say it's a pending divorce. It's a property that is co-owned by siblings who don't get along. Family member passed away, they inherited it, they're not in agreement about how the certain things about the property, and that leads to disagreements about who should list the property. So yes, you can have co-listing brokers, and that may save a great deal of aggravation where you have two owners who disagree. on who to hire. There are some rules when it comes to the MLS, and I'm highlighting MLS Rule 317, which does permit co-listing brokers. But the participants who are those brokers, they are required to submit something called a co-exclusive listing agreement that identifies which broker is being designated as the listing input agent. So only one broker can be the broker responsible for maintaining the listing, be identified at least on the MLS as the co-listing broker. I'm sorry, as the listing broker. Can't have a situation where two brokers are both basically managing the listing within the MLS. So the brokers have to agree to that. And there can only be one listing. So the MLS rules say you can't have basically two separate listings or two co-exclusive agents managing the same listing. That's how the rule is set up. How the two listing brokers agree in other respects to either market the property, compensation, that's between the brokers. But with respect to how the system will allow and how the MLS operates, only one can be identified as that listing input agent. All right. Another question that's come up a lot, and some of this has come up in connection with the changes in New York City rentals, which I'm going to cover next. But this is a statewide question. What fees can a landlord charge in New York State when it comes to rentals? Well, there is a law that was passed in 2019 and you need to be aware of this. I know a lot of you may only handle rentals from time to time. It may be that you handle one rental a year, one rental every 2 years, 3 years. This law went into effect in 2019, and it regulates statewide what fees a landlord can charge tenants. And the law in New York State, not just New York City, the entire state is the landlord can charge only up to 1 month's rent for security deposit or advance payment. Um, 1 month security, and that includes all securities. The landlord can't charge 1 month security and then a separate $400 security for a pet. Um, that's in excess. It's 1 month total security and 1 month advance payment. So no first month, last month. They can charge first month's rent up front and 1 month security. That would be it. Landlords cannot collect application fees, and landlords can't charge more than $20 for background or credit check fees. And the fees for that background and credit check also have to be waived if the applicant provides their own background or credit check that was conducted in the last 30 days. Um, just to back up a second, if the landlord also does provide, I'm sorry, if the landlord does conduct a credit check, they have to provide a copy to the tenant, in that case, and a receipt showing what was charged as well. All right, last question that's come up to the helpline this month that I just wanted to quickly go over. Has to do with that Housing Stability and Tenant Protection Act, and does it apply to co-ops and co-op leases? This is kind of a two-part answer. So, in the situation where the co-op lease is in connection with a sale of the unit, the answer is no. Those fees, the restrictions on fees don't apply. So when there's a proprietary lease and the tenant is the owner, the purchaser, the shareholder of that co-op unit, in that situation, the Tenant Protection Act limitations on fees do not apply. However, they do apply if a co-op board's renting out a unit that the co-op board owns, or a shareholder sublets his or her own unit and is acting as a landlord or sub-landlord. In that situation, the restrictions do apply. If there are additional fees that are required, application fees for a co-op owner to sublease their apartment, under the law, it's the co-op owner's responsibility to pay those fees. Those fees legally can't be passed on to the tenant. So yeah, Rachel has a question. If the sponsoring unit, if the co-op board is the owner of that unit and it is strictly leasing, not a lease in connection with a sale of that unit, and the person that will be occupying that unit is not the unit owner, the exemption to the Tenant Protection Act doesn't apply. As stated in the law, the exemption only applies in the case where the tenant will be the actual unit owner. All right, so we're going to now just move to the New York City Fair Act. This is a New York City law. It only applies to rentals within the five boroughs. That includes Queens, Brooklyn, not Nassau, not Suffolk County. Believe it or not, that was a question to the Legal Support Center in the last month. Is Nassau County one of the five boroughs? No, it's not. But if you're a Nassau County real estate licensee and you are handling a rental in Queens, this would apply to you in that situation. So, what is the Fair Act? Not to be confused with the Fair Chance Act, which has to do with criminal background checks. The Fair Act is New York City's Fairness in Apartment Rental Expenses Act. And what it does is says landlords can't pass the broker fee, their broker fee onto the tenant. And this again is a New York City law. There was some lawsuits or a lawsuit in federal court that had been filed to try to stop the effective date of this law. The lawsuit was so far not successful. It is still pending, but the request for an injunction was denied by the federal court judge. So it went into effect June 11th. So this law is in effect. It's been in effect for a little over a month. And again, it only applies to residential rentals and leases in New York City, not to the rest of the state. It There could be legislation at the state level that does the same thing down the road, but right now we're just talking about New York City. And so, what does this law say? It says specifically that a landlord's agent, so if you're representing the landlord, you're hired by the landlord, you shall not impose any fee on or collect any fee from a tenant related to the rental of residential real property. Period. So if you are public, and it even goes on to say if you're publishing a listing on behalf of the landlord, so in the case of an open listing, in either of those circumstances, you cannot collect from a fee from the tenant. Karen asked, does the law apply to private houses? Yes, if it's a rental and you are a broker handling that, you cannot impose a fee on the tenant. So the restriction is on the landlord's agent. It's not just apartment buildings. There's nothing that says it's just residential rentals, New York City. If you're handling a residential rental and you are working for the landlord, you're taking the listing for the landlord, you're advertising the listing on behalf of the landlord, you cannot impose fees on the tenant. The landlord would have to pay any broker fee that is owed to you. Um, so landlord's agents, what are you going to do? Well, you want to have a compensation agreement with and receive your fees from the landlord. So your listing agreement with the landlord for the rental should say that any fee that you've agreed upon is to be paid by the landlord. I know some firms may have, in the past, had stated in their agreements, and their common practice could have been that it would be the tenant who pays. If you have that language in your listing agreement, you want to change it for any rentals in New York City because that would be illegal. I mentioned open listings. If you're marketing an open listing, that means where you don't have the exclusive right to sell, but the landlord has said, yeah, you know what? You, Evan, I'm going to give you the right to market this. If you bring me a tenant, I'll pay you. But I'm also going to do that with other brokers, or I'm allowed to do that with other brokers. Same situation. Evan, as the listing broker, would not be able, or the broker under an open listing can't take a fee from the tenant. Whatever fee is paid has to be paid by the landlord. there's no workarounds here, so no co-broke restrictions. You can't say, well, the tenant's agent will pay me a portion of what the tenant paid them. Not allowed. You cannot receive fees as the landlord's agent from the tenant's broker or from the tenant. Tenants agents does this law doesn't prohibit a tenant's agent or a tenant's broker. So if you are working for a tenant, you are hired by the tenant, you're acting in the best interest of the tenant. So you have a tenant representation agreement. You've provided a tenant that agency disclosure form that says, I am working for you as a tenant's agent, and you have a written agreement with that tenant and you're working for that tenant to find an apartment, you can get paid in that situation. It's the landlord's agent who can't be paid by the tenant. I highly recommend if you're working as a tenant's agent in New York City or anywhere else, that you have a written agreement with the tenant, whether it's exclusive or non-exclusive. Um, Remember, NAR settlement doesn't require tenant representation agreements. It does require a buyer representation agreement. But I certainly think it's best practice to have a tenant representation agreement. Dual agency, it is allowed, but the landlord still has to pay the landlord's agent for whatever the landlord agreed to pay the landlord's agent. The landlord's fee cannot be paid by the tenant. If the landlord is going to be paid by both the landlord and tenant for the separate services it provided to each, it needs consent from both the landlord and the tenant. So remember, dual agency, you need to have the consent of both parties prior, for informed written consent from both parties to say, hey, I have your consent for me as I'm working for you as the landlord. I have your advance written consent to work with the tenant, and same thing with the tenant. You've given me advance written consent to work with this landlord. You also need their consent to be paid by each. But you have to be paid by each for the specific services you provided to that particular party. Um, Again, if you got questions about this, we've put together a lot more information on this. It's available on the website. There is a legal tip. There's an FAQ that we've put together. We also have links to the New York City FAQ that the New York City government has put together. But and we've also done a video on this that provides a little bit more detail. Fee disclosure requirements. In addition to the restriction on landlords' agents being paid by the tenant, there are other provisions to the Fair Act. And the important one here is that all listings or advertising for listings have to clearly disclose any tenant fees to be charged. So if there is going to be a security deposit, if there is going to be a background check fee, that needs to be disclosed in the advertisement, in the listing for the property. Before signing the lease, the landlords or their agents also have to provide the tenant an itemized written disclosure of all fees and include a short description of each fee. And that disclosure has to be signed by the tenant prior to signing the lease and retained for at least 3 years, and a copy has to be provided to the tenant. Um, all right. Enforcement and penalties. It's enforced by the Department of Consumer and Worker Protection. There are penalties that are listed here. They're fairly significant, but I will also say that in addition to those penalties, that $1,000, $2,000 penalty, a civil action can also be brought against you. So the tenant could potentially sue you. You could also risk licensure issues, which would potentially require you to forfeit any commission and and also be subject to any penalties with respect to your license. So this is not a law that you want to tread lightly on. It will be enforced by the city, and there are significant consequences. I see a question here about open listings. So in that situation where you are the question is open listing where a landlord allows the agent to advertise their apartment. and the agent has a tenant client. Is this considered dual agency? Yes. Even in an open listing, you are still initially being retained by the landlord as a landlord's agent. You're not the exclusive landlord's agent, but you're working as a landlord's agent. So you need that landlord's consent to informed consent to be a dual agent in the event that a tenant comes that you want to represent. And you also need to let the tenant know that, hey, I am working as a landlord's agent for the landlord. Landlords authorize me to act as a dual agent. Therefore, if you want, I can also represent you as a tenant's agent, but I need your informed consent. And be advised that if I am representing you, I cannot provide you an undivided duty of loyalty. I have loyalties to the landlord as well. And again, you've got to provide agency disclosure. You've got to make sure that you provided that informed written consent and you have consent of both parties to represent each. And then you have to make sure you have consent to be paid separately by each party for those services that you are providing. So just because you're working as this is just a general concept of agency, but just because you are working under an open listing, that doesn't change. You are still a landlord's agent at that point. So just make sure that you're aware, whether it's an exclusive or open listing, you are a landlord's agent. Same thing in the context of a sale. If you're retained on an open listing by a seller, you are a seller's agent at that point. And make sure that you are providing that disclosure in your agency disclosure. All right. Just really quick, a couple of questions that have come up on the Fair Act. Well, can I just have can the landlord just have the tenant pay the first month's rent to the listing agent? No, that's a workaround. Don't try it. I point back to the law. Law doesn't just say broker fee. It says the landlord's agent can't impose or collect any fee. So don't try to be creative. Don't try to come up with workarounds. What about voucher programs? It's not clear yet. I know other associations are trying to get some clarity from the different voucher programs and the city about how this works, because that payment's not coming right from the tenant, it's coming from a voucher program. My guidance would be never demand that a voucher program in New York City pay the broker fee. If the program offers it and they say they're permitted to do so, just make sure you got that documented in writing. I do think we're going to see some guidance come out on this soon. But this is sort of the best guidance I can give you right now when it comes to a voucher program paying a broker fee on behalf of a tenant. What about I already really went over this about splitting the commission. So what about the landlord's agent receiving commission split from the tenant's agent? Um, uh, I'm sorry, does the Fair Act prohibit a tenant's agent from splitting commission received from the tenant with a landlord's agent? Yes, the answer is yes. You can't do it. It's the same thing. It's basically a pass through. It's not allowed. Landlord's agent can't receive anything from the tenant or the tenant's agent. All right. I see there was a couple other questions that popped up on the Fair Act. I will answer those afterwards if you still have them. I just want to move on to a couple other topics. First one being the New York State property condition disclosure. Just make sure you're aware and that you've updated your forms. The property condition disclosure statement was changed as of July 1st. There is a new version of the statement. It's a minor change, but it requires you to make sure that you're using this version of the form. The only change was that there's a new instruction added under question 36 related to sewer systems. There's just a reference to the Department of Health website for septic system and operations. And it's really just this language that's added here in quotes. That's the change. It's minor, but it requires you, when you provide the property condition disclosure statement form to sellers, when you take the listing, make sure you're using the current version of the form. Department of State sent a notice out about this. LIBOR, NYSAR have sent notices, but I know you probably get a couple hundred emails a day. So in case you missed it, make sure you're using the proper form. Again, it's on the Documents on Demand page. It's on the DOS website. And look for that question 36, that additional language, then you'll know you have the right form. Nothing else has changed regarding the property condition disclosure statement. Your obligations remain the same. So you still, as the listing broker, have the duty to inform the seller of their obligations under the law. There is a statement in the LIBOR exclusive right to sell agreement that does that. We also have a form that you can use for that purpose to make that disclosure. Buyer's agents, you do have a duty and also seller's agents, if you're dealing with a prospective buyer as a customer, you have to let the buyer know about their right to receive a property condition disclosure statement prior to execution of the contract. That is your duty. You don't have any other duties under the law. The seller has to complete the property condition disclosure statement. They have to give it to the buyer before the buyer signs the contract of sale. Does that mean that's when they have to give it? No, the seller may say, "Hey, I want to provide it earlier." The buyer may say, "I would like to see it before I do my home inspection." That's fine. It's up to the seller as to when they want to provide it. Um, but the buyer has no legal right if the buyer, to receive it prior. So if a seller for some reason says, "I don't want to provide it until my attorney provides the contract of sale," the buyer really doesn't have any recourse other than to say, "Well, I don't want to go forward with the deal then." But it absolutely has to be provided prior to the point when the buyer signs the contract of sale. And just remember, and I've heard there are some attorneys out there who still have not gotten the message. There's no longer a $500 credit. It can't be stated in the contract that the seller's providing the buyer a $500 credit in lieu of providing a property condition disclosure statement. That was taken out of the law last year. So that should not be something that you are letting sellers or buyers know, and certainly attorneys should not be including that in the contract of sale. Just remember, property condition disclosure statement applies to residential real property. What does that mean under the law? It's improved 1 to 4 family dwellings. Doesn't include vacant land, doesn't include condos, doesn't include co-ops. There's a whole list of other exclusions under the law. The main ones are bank-owned properties, court-ordered sales, fiduciary sales. So if it's an estate, if it's a trust, you've got an executor, a trustee who's the person signing that listing agreement. New construction, all of those are exempt from the property condition disclosure statement. If you need any kind of update, refresher on this, just go to lirealtor.com /PCDS. We have a whole FAQ on the property condition disclosure statement for anybody needing a refresher on that. Next topic I want to just get to quickly. You may have read about over the last couple of weeks, the Code of Ethics was changed. Standard of Practice 10-5, which is under Article 10, which prohibits discrimination in connection with your real estate and employment activities, was modified. It was updated to basically 10-5 was a change that had been made a couple of years ago. I think NAR realized the language was a little too broad, and there was some inconsistencies in the way it had been enforced. And so 10-5 and policy statement 29 were updated. And these changes went into effect immediately. There were also some other changes to the Code of Ethics that went into effect immediately, and those relate principally to the NAR settlement and just removing language that had to do with offers of compensation on the MLS from the Code of Ethics. So back to 10-5 though, that was introduced in 2020. It was addressed to basically prohibit any kind of hate speech, slurs, harassment based on any of the protected classes identified under Article 10. And it also expanded the Code of Ethics to apply to all of a realtor's activities, whether they had to do with real estate or not. So it was an expansion of Article 10 and the Code of Ethics. And I think it created some questions. And because of that, NAR, really wanted to just clarify what the standard was meant to cover. And here's the change that was made. So as it now reads, and this is the code that's in effect now, the standard that's in effect now, realtors in your capacity as real estate professionals in association with your real estate business or in your real estate activities shall not harass any person or persons based on race, color, religion, sex, disability, family status, national origin, sexual orientation, or gender identity. And then they go on to define what harassment is, and it's unwelcome behavior directed at an individual or group based on one or more of the above protected characteristics, where the purpose or effect of the behavior is to create a hostile, abusive, or intimidating environment which adversely affects their ability to access equal professional services or employment opportunity. So this is the new 10-5. Um, I think there was some discussion, at least in some articles, saying, "Oh, this weekend is a walk back of what the prior language was." I don't think that's the case because if you look at what now it states, real estate related activities is pretty broad. So also policy statement 29 was also amended to only apply the code to your in association with your real estate business or in your real estate related activities. Um, so I say real estate related activities is still a pretty broad area, right? Talk about advertising. Your real estate related activities when it comes to advertising really can include anything on your social media where you're using that in some way to promote yourself as a real estate professional. So I think some people were worried saying, well, like this gives people license to harass others on social media based on a protected characteristic. If a realtor's identifying themselves as a realtor on social media or using that social media account to promote their business, promote their open houses, their sales, their brokerage, that's considered real estate related activity. So I think the code of ethics would still apply in that situation. Also, just a reminder, if anybody does think, oh, this is a walk back of what being a realtor is, our bylaws and all realtor association bylaws still have certain language that continues to hold realtors to a high standard. It may not be in the code of ethics, but our bylaws say that every realtor member shall maintain a high level of integrity and adhere to the association's membership criteria. Any violent act or threat of violence to person or property, hateful conduct, or acts of moral turpitude impacting the public shall not be tolerated and may be cause for disciplinary action up to and including termination of membership. So I say that to show that although the code of ethics may have been narrowed just a bit or clarified just a bit, um, any realtor who's going to engage in any violent act, threat of violence to a person or property, hateful conduct, or acts of moral turpitude impacting the public, regardless of whether it's in connection with their real estate activities or not, can still be removed from membership. So we do still have a very high standard, I think, to be a realtor. And hopefully, I just think it's worth making that clear to everyone that there is a real difference in being a realtor and what being a realtor means. All right. I think I only want to cover about two or three more topics, and I do want to quickly touch on lawful source of income. I try to touch on it in every class I teach, and that's because it still remains the number one area of undercover testing in New York State. And I think it also still remains a problem area in terms of compliance. And that's why I think it needs to be something that just continually gets reinforced to every member because you all may be subject of some kind of testing. Even if you don't provide services on rentals, you may receive a call about a rental. You may receive an undercover tester calling you about a rental. And you may have people in your office that handle rentals, and you need to be able to properly guide them and train them when it comes to lawful source of income laws. So, what is lawful source of income? Well, I first start to say, well, what it's not. Um, as a housing provider or a broker, I can ask any prospective tenant about their income and where it comes from, and I could ask them for documentation. So I know, can you afford to pay for this housing? That's fine. I just have to accept all lawful sources equally. I can't favor one source over another. I can't say I like tenant A because they get their income from a job versus tenant B who gets their income from another source. Any source that's lawful. And here's all of the listed sources. So I can't say, yeah, you know what? I don't like that this tenant gets some of their income from child support or alimony or Social Security or housing vouchers. Section 8. I have to treat all of those sources equally. If they have the income to pay the rent, that's it. It doesn't matter where it comes from. And when it comes to vouchers, if they have the ability under that voucher to cover the rent, that's it. End of story. I can't say, well, I don't really like that or those people. It's no different than if you were discriminating based on a religion, a race, any other protected characteristic. And I mentioned the reason why I bring this up in every class I teach is because it's a problem. Our industry, whether it's real estate licensees or housing providers, still aren't getting it. Um, Here's just a sample of some of the cases as recent as the last 6 to 7 months. Major settlements based on undercover testing for people saying things like, oh, this apartment doesn't participate in programs, or we've got enough, we've reached our quota of Section 8 tenants. It doesn't work that way. There are no quotas. Landlords have to accept vouchers. If it covers the rent, and they can afford the apartment, that is it, period. Um, just here are some of the examples of what source of income discrimination looks like. Making the statement, I don't work with voucher holders, or I have to find out if the landlord does. If you as a broker have the listing, the landlord has to work with voucher holders, period. They can't say I don't work with them. If that's what they want, then they can't work with you. You cannot handle that listing. So what do? You're never going to turn away any prospects because they receive financial assistance. So if you get a call from somebody who says, I have a voucher, can you help me? The answer is going to be yes. We help everybody. And you're going to ask the same questions you would anybody else. Okay, can you tell me what area you're looking in? Where are you looking for an apartment? How many bedrooms are you looking for? What's your price range? If they tell you you have a voucher, you're going to show them the same apartments you would anyone else. The one difference would be if they say they have a voucher, you say, okay, can I get a copy of your voucher? Let me get the name of your caseworker. I want to find out the details of your program. Let's find out what the program covers. Then I can help you figure out what apartments we can find for you. It's the same process. It's just like if somebody calls you from a different race, a different religion, a different national origin, you follow the same process. It's all about just having a system in place. And if you follow that system every time, uh, there's no risk of any kind of discrimination. I mentioned this earlier. If the owner says they won't accept vouchers, you say that I have an obligation to work with voucher holders. And if you can't work with that, I'm not going to work with you. Um, the best decision you can often make is in a situation where a landlord, a seller is pressuring you to discriminate, or they're giving any kind of evidence or indication that they are going to discriminate. Terminate the relationship. You don't need to continue to work with someone in that situation. You're only putting yourself at risk. I was told this years ago, even in private practice as an attorney. If you're uncomfortable with that client and what they want to do, walk away. Don't take that client. It's that simple. You don't have to work with people that are going to break the law. You don't have to put yourself at risk. This question comes up a lot, and so I've added this because it comes up to the Legal Support Center. What about credit checks and credit scores for voucher holders? Let's say I have a landlord who wants a minimum income, a minimum credit score. Can I apply that to a voucher holder? Um, well, first, if the voucher covers 100% of the rent, so let's say it's a $2,300 a month apartment and the voucher covers 23, 24, $2,500 a month. No, you cannot. At that point, that tenant has met any possible income requirements, any possible credit requirements. The government is 100% covering all of the rent. The landlord cannot require a credit check, reject the tenant based on income or negative credit history. If the tenant's paying a portion of the rent, let's say the voucher is only going to cover 70%, 80%, the landlord can consider credit on a case by case basis, but I will say that requiring some kind of minimum credit score can still violate the law. If it excludes anybody with a voucher, that is the same effect as discrimination. I mean, you have to remember many voucher holders, the reason they're getting a voucher is because they have low or no credit. So if you require a specific credit score and you effectively exclude anybody with a voucher, that would be considered discrimination. Most Almost all of these voucher programs have vetted the tenants to make sure that they have the resources available to pay and cover their share of the rent. And the landlords can speak to the voucher programs about what information the voucher programs use to determine the tenant's ability to pay that portion. Asking for that information would make sense. But applying a credit check or income requirement can certainly lead to discrimination, and landlords have to be careful in that regard, where the tenant is paying a portion of the rent. I'm going to just conclude with some tips on advertising. I just want to make you aware of. Please look at the handouts I gave you. You can look at them after the class. It's a good idea to do your own advertising audit every 6 months. Look at everything you've put out on your internet site, on your social media sites, in print, your business cards, your email signatures. Just make sure you're following all of the DOS guidance and requirements for advertising. The checklist that's one of the handouts, that's the checklist DOS uses. I can assure you, based on everything I know and I've heard, if DOS opens up a complaint against you in any way, even if it's an unfounded complaint, they will look at your advertising. They randomly audit real estate licensees for advertising. That's the checklist they use, and they will fine you if you have violated the law. So make sure you're using your proper title. Whatever your license says, that should be on your business card, your email signature, your website. I see a lot of real estate licensees out there advertising themselves as a real estate agent, licensed realtor. Those are not your license titles, right? You're either a real estate salesperson, a real estate broker, or associate real estate broker. That's it. It's one of those three. That should be on all of your advertising. Um, a couple other things about corporate titles. Unless you're the broker of record, you can't use them. Identify your brokerage. If you're a member of a team, that's great. And you can identify that, but you have to identify your brokerage. Your team is not your broker. Your broker is your broker. You've got to identify your brokerage name, your office address, your phone number. And I know some of these things may sound silly, but they will, if you don't do them, you're going to get fined. And I think there's a big benefit to doing it the right way from a professional standpoint. You look more professional if you follow the law. There's never a question then in the mind of the public. Well, who does that person work for? What's the Jones team? I don't understand. And then they Google Jones team and they're like, well, who is that with? Is that with brokerage A or brokerage B? Just do it the right way. It will help you. It will help you get more business. Be careful with nicknames. You can use them, but make sure you use your full license name. Make sure social media, you're doing it the right way as well. Um, Last thing, copyright infringement. Make sure that you're not using someone else's photos. This goes for MLS photos. Even if you are the buyer's agent and you want to promote yourself as the buyer's agent, That doesn't give you the right to copy the listing broker's photo into your social media post. It's copyright infringement. You don't own the photo. Never use a photo that you don't own, that you didn't take, that you don't have written permission to use. If you do, you're committing copyright infringement. And you may tell me, Patrick, no one's ever going to find that out. They do. Other brokers look at other brokers' social media posts. But you know what the big issue is? AI. I am not even kidding. There are now AI programs and bots out there that scan the internet looking for copies of photos that other people have posted. And then those companies then hire attorneys that send out notices, and they do it to make money. You know, just how your iPhone, if you have any of these newer iPhones, you can hit that little button on the side where you can search, like you can take a picture of my watch, right? And basically search and come up with from the photo anything on the internet. They use programs like that to search other websites and match photos up with photos that other people took and find copyright infringement. So be careful. Don't, right click and copy a photo from another website and put it on your website. You're putting yourself at risk for like tens of thousands of dollars of fines. So just really be careful. I think this is a major area that's going to explode in the next few years. You're going to see a lot of, not just in real estate, but a lot of businesses be subject to copyright claims and lawsuits based on the unauthorized use of photos. And I do think it's a big problem in real estate because what do you like to do? You guys like to use photos, and that's great. It's 100%. It's a good thing, but don't use someone else's photos, even for the purpose of your social media page, marketing. I really think, especially long term, it's going to lead to big problems. So with that, I know I'm up at my hour, so I am going to end my presentation. I thank everyone for attending.